Slideshow from beginning.
Yes.
There we go. Yay, we got it. Okay.
All right.
All right. My apologies.
You're good.
Okay. So my topic for today is my bewildering brain toils in vain. Traumatic brain injury, the criminal trial process in the case of Lisa Montgomery. And at least one of the attendees here, Phil, I'm talking to you, sent me an email that he knew which Bob Dylan song this was from. I was impressed. And perhaps others of you do as well. And we'll get to that a little bit later on. This talks about me. We don't need that. We don't need a disclosure. We don't need a disclaimer. Why are we here? We're here to talk about the relationship between TBI and the criminal trial process, going beyond the death penalty. Lisa Montgomery is a famous death penalty case, going beyond that, and how we think case law can be applied in the future to these questions. And we're going to try to dig a little into the gross, the terrible legal errors that permeated the entire trial process in the Lisa Montgomery case that led to her execution. She was the next to the last person executed during the Trump administration and the last woman to be executed, and hopefully she will be the last. So what is this all about? Introduction, this is not going to be a surprise, I think, to just about anybody. People with TBI have a much greater risk of becoming justice involved. I'll give you some numbers later. And people accused of criminal behavior have a high risk of having traumatic brain injuries. There is often no diversion opportunity. Very often, expert witnesses evaluating this population has no real experience with the population. And attorneys have no real experience in dealing with people with TBI. And one of the things that I talk about all the time, and when Julie told you I've litigated to the United States Supreme Court, I second sat, that means I was the other guy at the table, the case of Strickland v. Washington, which is the most cited US Supreme Court criminal case in history on effectiveness of counsel issues. So one of the things that I am always looking at, whatever I'm writing about, whatever I'm talking about, whatever I'm consulting on, is how competent is counsel in the case. And that's a huge issue in TBI cases. I am then going to turn to therapeutic jurisprudence, which those of you who have heard me in the last 30 years, I guess, know I always turn to, because I think that is the best solution to remediate this entire range of issues we're facing. So why am I talking about this? Well, every year the relationship between TBI and the law becomes more and more important. It's there in the case law, it's there in statutes, and it's also there in conversations between lawyers and forensic specialists. And it had never been before. We know there are at least 2.5 million, and I think the number is higher than that now, TBI-caused emergency department visits. The overall offender population says 60%, but since it is so under-evaluated, I think it's higher than that. The public knows borscht. What amazed me was very few things amazed me. 42% of people polled believed that if you hit somebody in the head exactly where his first TBI was, that would improve his memory functioning and help solve his TBI problem. You can't make that up. And again, because so many people with TBI go diagnosed, attorneys may not know this. They may not understand that certain behavioral manifestations of their clients that might be relevant, either as a defense or as mitigation, might come from TBI. I was a public defender many, many, many years ago. Think of me having black, very dark black curly hair and wearing, bell bottoms. That was a while ago. There's no question that multiple clients of mine had TBI. It was almost never mentioned. It wasn't until 1990 that there was any reported criminal case that mentioned traumatic brain injury. And that's really remarkable. And again, attorneys may simply not know about it. The Lisa Montgomery case is one I'm going to be talking about later on. She was seriously mentally ill. She had serious brain damage. There was no question about that. Her lawyers did a terrible job at trial. She was convicted, sentenced to death, and ultimately executed for the murder of a pregnant woman and the kidnapping of this woman's unborn child. As you'll see, it was just before the time of the new administration taking over. Her case reflected all that is wrong with the way we treat criminal defendants with TBI. It's a catch-all for so many different kinds of organic brain injury, a bump, a blow, a jolt to the head, a penetrating head injury, maybe mild, maybe severe, maybe it lasts a few days, maybe it lasts a lifetime. And it can include impairment of thinking, impairment of memory, impairment of sensation, or impairment of emotional functioning. So it is not a one size fits all. It is many, many different sizes. And a lot of this depends on where in the brain it took place. And many connections exist between those people who have suffered TBIs, and shifts in personality, shifts in executive function, shifts in impulse control. In other words, it affects just about everything. So again, we begin with the reality that research has established that people accused of criminal behavior are at very high risk of having traumatic brain injuries, and these claims are very common in criminal cases, especially in death penalty cases. So what's the story with Lisa Montgomery? She attacked and killed a woman named Bobby Jo. It's a horrible crime, there's no question about that. A woman named Bobby Jo Stinnett, who was 8 months pregnant. She strangled her, butchered her with a kitchen knife, cut her unborn child from the womb, and tried to pass the child off as hers. She was convicted of kidnapping resulting in a death and was sentenced to death. And I've listed all, if you want these slides, you have all of the citations in all over many cases there. She had brain damages from beating as a child. She suffered from both serious mental illness, continual sexual and physical abuse at her stepfather's hands, beginning in her early childhood, and it gets worse. Her mother started, and this is almost impossible, at least to me, and I've been in this business forever, but this one is pretty much impossible for me to believe. Her mother sexually trafficked her when she was a small prepubescent child, allowing her to be gang raped by adult men on multiple occasions, telling her she had to earn her keep in the house. She was tortured for years, documented brain damage, severe mental illness. Her connection with reality was severed. And all of this information is accessible in the Death Penalty Worldwide, which is run by Cornell, in an article by Lisa Montgomery. And if you want to read more, it's all there. And she would fantasize about becoming pregnant. The district court it noted these details of her history of physical and sexual abuse, her history of brain impairments, her history of mental disabilities, and it basically ignored the impact of all that history. Interestingly, this takes place in Texas, and I've written 2 articles, and I'm working on a third, about how terribly the Fifth Circuit has done in death penalty cases involving defendants with serious mental disabilities. And those the first 2 articles that have been written were written too early for this case, but this is so clearly part and parcel of that. So again, I will be coming back, I will be coming back to Lisa Montgomery's case later, but we also have to think about a lot of other more benign, I guess you would say, criminal cases in which TBI might be a factor. And we start out before the trial, looking at pretrial motions. I was a public defender in the early 1970s, as I said, and the cases, so many of the cases turned on pretrial motions, what are called MAP motions, motions to say there was an illegal search and seizure, or Miranda motions, motions arguing a confession should be excluded. When in both cases, the court has to look at competency. Was a defendant competent to give consent to a search or to waive the Miranda rights? And interestingly, I wrote about this nearly 20 years ago. After the Supreme Court decided the Godinez case, I realized that we spent a lot of time looking at competency to stand trial, competency to plead guilty, competency to waive counsel, but virtually no time at all looking at competency in all the other very, very important aspects of the criminal process, both before and after trial. And this piece of mind in behavioral sciences, well, it's 18 years old, but when I've gone back and looked, and there's new cases, of course, but very, very little has changed. Remarkably, and I was really stunned by this, there have been only a handful of cases, and this involves all defendants, not just those defendants with TBI, on the question of competency to consent to a search. And the courts are split, and you'll hear me saying this often. Courts are split between those that say that mental competency is relevant to an inquiry determining voluntariness of consent, and those that say that there is no authority for the proposition that incompetency renders consent to the search invalid. And that's kind of a huge puzzlement to me. If somebody is not competent to consent, how can that still make the consent valid? And I cite a couple of cases here, including a Fourth Circuit case that says competency is irrelevant. The Wendahate case, a Florida case, despite the fact the defendant had a cognitive disorder secondary to his TBI, the court said it had no impact whatsoever on his ability to freely consent to the search and seizure. In Taylor, also a Florida court, this was state, the other was federal, the court said the fact that he had a documented TBI had no impact on his ability to give consent. We know that TBI may make a person more likely to produce false confessions and even more at risk of incompetency to waive constitutional rights, such as, for instance, the privilege against self-incrimination. Bruce Frumkin, who I expect many of you know or know of, has written about this extensively, and he's really one of the few that I have found sort of the name forensic psychologist or psychiatrist who has focused on this issue in this context. A death sentence was carried out in Missouri 20 years ago, and the defendant confessed, but the jury heard almost no evidence about his TBI. In another, in case involving a jailhouse admission, a defendant with TBI was unsuccessful in seeking to exclude the introduction of these recorded telephone calls. He had no memory as to whether or not the events took place and argued these really couldn't be seen as admissions. He lost. TBI also has a profound impact on a defendant's ability to waive constitutional rights. Now, one of the very, very few aspects of criminal procedure that has not changed for, I said almost 80 years, it's over 80 years, is the definition of waiver, an intelligent relinquishment or abandonment of a known right or privilege. I read that when I was in law school in the late 1960s. It's still the law today. It has to be voluntary. It has to be made with full awareness, both of the nature of the right being abandoned and the consequences of the decision to abandon it. Well, think about that in the context of defendants with TBI. And courts here, again, are split. In the Ward case, federal habeas, in the Illinois case, a federal habeas corpus was granted because the defendant could not voluntarily and intelligently waive his right to testify. And the court noted, the appellate court noted, that the trial court made no clear and straightforward effort to ascertain he understood the nature and implications of the right he was waiving. And in so many of these cases, I have to stress this, the state court judge, especially much more in state court than in federal court, pays no attention to this. Just let's move on. And I think that's really one of the serious issues that's here. On the other hand, in State v. Larson, a Minnesota case, conviction was affirmed where the state court found that his untreated TBI did not disrupt his ability to understand what was going on. Remarkably, the trial court rejected the defendant's motion to be evaluated by a neurologist and a psychiatrist. So the appellate court in Minnesota never saw the potential testimony that might have explained this, and the defense counsel could have argued to the jury. It was a non-issue. Well, what about incompetency to stand trial? And again, Frumkin in one of his articles points out that courts are very skeptical. Courts are skeptical about all claims raised by defendants. Courts are skeptical about all claims involving mental illness. There is no question about that. And I've been in this business for almost 50 years. It hasn't changed at all. But courts are very skeptical about the presence of TBI and causally related incompetence. In the Wiggin case, there's no reasonable cause to believe he was incompetent, despite claim of memory loss and cognitive impairment caused by brain injury, because the trial judge had seen the way the defendant interacted with his lawyer. And I talk frequently, I may talk in these slides, I'm actually not sure, about what I always call ordinary common sense. I see it this way, therefore it is. I see it this way, therefore everybody sees it this way. Utterly self-referential. How many judges have I been before and you say, oh, Mr. Perlin, I've seen that before, I know exactly what it is, with no consideration at all about what's going on that maybe the judge can't see. Maybe the judge is not an expert in this. And this is the First Circuit, which is usually a very, very good court. In this court in New York, also generally good. So defendant did have a TBI, but he gave coherent responses to the court's inquiries, and there was nothing to indicate he did not understand the charges against him. There was no expert testimony proffered in this case. And such expert testimony, I believe, would have been astonishingly valuable to the appellate court in coming to the decision. Now, we do know, interestingly, that defendants with brain injury are more likely to be found NGRI than others. And the reason for that is this. People feel that if you have a neuro image or if you have an x-ray or something, that is not falsifiable. You can see, oh, this is red, this is yellow, this is orange. It's not like a defendant saying, oh, I woke up in the morning and I felt blah, blah, blah. So it's more likely a defendant with documented brain injury is going to be more likely to be found NGRI, but a defendant on TBI alone is generally not enough to support an insanity defense. And in reality, as Professor Paul Litton points out, it is more relevant to diminish responsibility, which is not a defense in most jurisdictions now, but that might be relevant to mitigation in sentencing. And again, and I've written about this my whole career, and I cite a couple of pieces here, how negative and stereotype beliefs fuel legislative decisions, judicial decisions, jury decisions about the insanity defense. But if TBI evidence is presented, and if valid and reliable evidence is presented to the fact finder, it may be possible for defense counsel to respond successfully to the damaging and inaccurate mythic beliefs that plague the insanity defense. For anyone who wants to read a real short, it's maybe 12 pages, summary of what I've done in this area, the article in the book edited by Mark White is your place to go. And like almost all my articles, it's available for free and easy download on SSRA. But consider the reality. The vast majority of insanity TBI cases relate to adequacy of counsel cases where defense counsel never bothered to seek expert opinion. The strangest of these is Anstinson versus Davis, a Colorado case in which the trial counsel told defendant that he could not plead NGRI because such a plea based on TBI is not allowed by law. Dumb. But even without such blatant inadequacy, the experience of counsel in presenting TBI evidence can be just as detrimental. It can also be in death penalty cases relevant at least 3 different stages: findings of future dangerousness, mitigation, and competency to be executed. We have known for 45 years since the Jurek case that a state statute is constitutional if it says a person can be executed, if there's a probability he would be a continuing threat to society. The Barefoot case that I expect most of the people in the room are familiar with, in the world are familiar with, the Supreme Court said this testimony is fine. One of Dr. Grigson's infamous case in which he had never examined or evaluated the defendant. And in Barefoot, Justice White put so many of his chips on this piece that as a result of vigorous cross-examination, the jury will be able to separate the wheat from the chaff. I've been studying the job that lawyers have done in insanity defense cases for the last 40 years plus, and this ain't happening. And Professor Haramsachuk's article that I cite here from 1990, it calls this cavalier, I think that's almost too nice, is a very helpful one to look at here. The adversarial process cannot be trusted here. Predictions of future dangerousness are no better than random guesses. In the civil context back in the 1970s, Tom Litwack, a professor for many years at John Jay, and Bruce Ennick, one of the great civil rights lawyers for mental patients in history, wrote an article that was called something like Flipping Coins in the Courtroom. In other words, if you flipped a coin, dangerous, not dangerous, you would do just as well as the experts. And sadly, that's often still true. Well, how does this relate to defendants with TBI? Professor Jonathan Pincus has evaluated death row inmates and found, no surprise, most were victims of child abuse most sustained brain injuries in childhood, and most had been diagnosed with ADHD and conduct disorder. John Fabian found 61% of persons in this category had TBI. I do know that in the years that New Jersey had a death penalty, and I'm glad to say I never had a death penalty case in New Jersey, there was only one person ever on death row, and he was a contract killer. He was like a TV movie. He could have been in Law and Order. But other than that one case, there was not a single case that a person was on death row who had not suffered serious abuse as a child, including brain damage. Daniel, frontal lobe TBI, the court rejected his finding of that. The court rejected the defendant's argument that the finding of future dangerousness was an error, saying he had an escalating pattern of disrespect for the law, and his apparent lack of remorse was a factor in this assessment. If I were teaching this in a class in which my students were having an exam, I would say, take that word remorse and put a yellow magic marker on it, because that is such a key to so much of criminal procedure in this area. The judge's perception, does he look remorseful? Harken back to the case of Riggins versus Nevada in 1992 on the question as to whether or not an insanity pleader could refuse medication during trial, and Justice Kennedy's brilliant concurrence of saying that because he was receiving so much of the medication, enough to quote zombify an elephant, I believe was the words used by the expert, that he could not possibly look remorseful, as jurors expect people to look remorseful because that might be the way they look remorseful or the way they've seen remorse exhibited on TV shows. But what about mitigation? The key elements were articulated over 40 years ago, and they basically stayed the same, although the big change in mitigation law over the years is now the Supreme Court cases tell us that the trial court has to listen. Does his suffering evidence expiation or inspire compassion? Whereas cognitive or volitional impairment affect his responsibility? Was he less affected than the mentally normal offender by the deterrent threat of capital punishment? Would the exemplary value of capitally punishing the offendant be attenuated by the difficulty people would have with identifying by him? And Professors Liebman and Shepard wrote this in 1978. That's a long time ago for law review years, but it is as valuable today as it was then. Well, in 2005, the American Bar Association said, we agree. And they said specifically, a defendant should not be executed or sentenced to death if at the time of the offense, he had significant limitations in his behavior and functioning as expressed in blah, 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 or a traumatic brain injury. So the ABA has been on record on this for 16 years. Now, think about the Montgomery case. Startlingly, defense counsel never engaged a mitigation specialist. But, on how did a specific injury have an impact on an individual's capacity to make choices is extremely important in mitigation. Well-documented brain injuries, medical records, significant injuries to provide strong mitigation. None of this was done in the Montgomery case. We know that the presence and severity of brain damage can be critical. It wasn't there. The introduction of a defendant's TBI could prove to be an effective tool during mitigation. Dorothy Utnow-Lewis's study from 35 years ago, she evaluated 15 death row defendants. Everyone showed evidence of brain injury. Not much has rebutted that since. The case law in lower courts on the death penalty is a little mixed. In Cerisi, the Florida Supreme Court, which every once in a while steps up to the plate. David Shapiro, maybe later you can explain that to me. Why some days the light bulb is on for the Florida Supreme Court and some days it's off. I can't figure it out. They granted a defendant a new sentencing hearing because he did not receive competent psychiatric evaluations that had adequately investigated possible brain damage. On the other hand, the Ninth Circuit, a panel originally found that counsel's work was damaging to his defense at sentencing as he failed to seek neuropsychological testimony to show the TBI, but the full court vacated, saying even if the accident, the source of the TBI, had an effect on him, it hardly changed an altar boy into a callous criminal. And think about the Ninth Circuit's use of words there. hardly changed an altar boy into a callous criminal. Think about the stereotyping on both ends, how that works, how the nuance is completely missing. And most cases, most state level death penalty cases downplay or ignore the significance of TBI as a potential mitigator. Long v. State, the court said it's not cruel and unusual despite the TBI because there was no evidence that it was only the TBI. So it's kind of an all or nothing pattern that the court needed to see. In Jackson, where the lawyer did a good job, he called 7 mitigation witnesses, a psychologist, his probation officer, the mother of 2 of the victims, all that testified as to his remorse, his anger disorder, his traumatic brain injury, his low IQ, and their opinion he should be punished but not sentenced to death. No matter, he was sentenced to death nonetheless. Now, on the question of competency to be executed, which I am actually working on a case on an article on as we speak, the Supreme Court in Panetti said, a state may not execute a prisoner whose mental illness prevents him from comprehending the reasons for the penalty or its implication, or who is unaware of the punishment he's about to suffer and why he's about to suffer it. And what Panetti did was it expanded on a former US Supreme Court case called Ford versus Wainwright from 1986. And it really gave it a lot more life, or at least it did in paper. But most courts are unresponsive. Here is the Florida Supreme Court again on another day. It said the fact that he suffered from severe traumatic brain injury and severe mental illness, that did not exempt him from the death penalty. A federal court found elsewhere that there was no national consensus against executing defendants who suffer from traumatic brain injury, and that a motion for categorical exemption was meritless. In Montgomery, the Lisa Montgomery again, the district court said an expert witness's proffered testimony, this is later, this is not on the trial, this is on post-conviction, was irrelevant to the factors that she had pled, and it was because it did not bear on her character, her prior record, or the circumstances of her offense. And of course you can say, well, sure, if she was not a person who had been gang raped from the time she was 5, maybe then, but that was not the case. When she was on death row, an expert filed an affidavit saying the kind of brain damage she had affected her ability to have accurate perceptions of reality. I believe this was Dr. George Woods, I'm not 100% sure. And he said she was unable to rationally understand the government's rationale for her execution as required by Panetti and by Ford, but to no avail. A stay was granted, it was vacated by the Supreme Court, and she was executed hours later, this in 2011. Again, TBI has great potential relevance to all 3 of these major death penalty issues. And again, if you're going to think about the death penalty, I think you must always think of all 3 of these together: dangerousness, mitigation, and executability. And it was all reflected so clearly in Montgomery's case. Sometime TBI is taken seriously, but the vast majority of cases, I can't quantify it, well, I'll try, maybe 80% of cases have not taken it seriously at all. The key issue here, and I call it hiding in plain view, and I've already alluded to it, is the extent to which counsel gets the importance of these issues. No matter what aspect of criminal procedure we look at, there's one constant. The adequacy or effectiveness of counsel is globally the most important issue to consider. Did it undermine the proper function of the adversarial process so that the trial could not have been relied on as having produced a just result? And as I said, I second sat this. David Washington is the only client I ever had who was executed. So still, some 37 years afterwards, it still burns a hole in me. I've written about this, and again, here in the article with Talia Royberg-Harmon, who's a criminologist, and Sarah Chatt, who I think is a psychologist, The World of Still-Eyed Death, the failure of Strickland to ensure adequate counsel to defendants with mental disabilities facing the death penalty. I call it what the Fifth Circuit did bizarre and frightening. And those of you who want to really dig into the weeds on this, I recommend this article, which is available on the Michigan website. Look at the Montgomery case. Her trial attorney had visited her only 3 times prior to trial. When I was head of the public defender's office in Trenton, somebody was representing somebody on shoplifting, they would have gone to see them 3 times. He never investigated the relationships between her symptoms and her history. She seemed impassive and unemotional to the jury. That was a result of powerful antipsychotic medication. Again, go back to the words that Justice Kennedy used in his concurrence in Riggins 29 years ago. And I'm certainly willing to bet a lot of money that the lawyer assigned to this case had never read the Riggins case. Okay, enough on that. What about therapeutic jurisprudence? Those of you who have heard me speak, can play Candy Crush now for 5 minutes. Those who haven't, Candy Crush away. David Wexler and Bruce Winnick created this, saying that the law can have, and the law meaning statutes, case decisions, and what lawyers and court officers do, can have therapeutic or anti-therapeutic effects. And it questions, can the law, can rules, can procedures, can roles be reshaped to enhance therapeutic potential and not subordinate due process? And that's really kind of the heart of the issue here. The law's use of mental health information to improve therapeutic functioning cannot impinge on justice concerns. Therapeutic jurisprudence look at how the law actually impacts, Julie, that's a quote, that's not my word, people's lives. It supports an ethic of care. It tries to bring about healing and wellness. It tries to value psychological health. Professor Amy Ronner has characterized what she calls as 3 V's: voice, validation, voluntariness. She says these 3 V's are the heart of any legal exchange, any legal interaction. And without these 3, one cannot comply with therapeutic jurisprudence. So think about it in the context of TBI. Dignity, voice, validation, voluntariness. Many defendants with TBI have never been in a situation in which they were able to obtain any of these. Recognizing that there's a physical component to this disability could help to comport with these principles. Dignity is a sine qua non of therapeutic jurisprudence. People with TBI who don't have the ability to have expert testimony in court, people with TBI whose counsel doesn't ever inquire into any of these questions, does not have dignity in court. Well, what about mitigation? The relationship between TJ and the intersection between TBI and mitigation should be clear. And we know that the National Association of Sentencing Advocates, very specifically in its sentencing and mitigation trainings, grounds them in these core principles of therapeutic jurisprudence. The Montgomery case is a perfect example of what happens when TJ principles are ignored through every aspect of pretrial prep in the trial. In another article that I've written, and I presented this, I've actually presented this twice, once at the Papadal group in Boston, and once at Ken Weiss's group at the University of Pennsylvania. I said you need more than one expert in the case. You have one expert to say, I evaluated Mr. Jones, Mrs. Jones, and blah, blah, blah. And you need another expert to tell the jury why everything they think about, whatever the topic is wrong, that it's based improperly, relying on heuristics, especially the vividness heuristic, the confirmation bias, etc. And their common sense is flawed. And again, this article deceived me into thinking I had something to protect. For anyone interested in this, who likes the idea, I hope, of having multiple experts, that's where you can find it all. The public, and this includes judges as well as jurors, what's their knowledge base? Action news on television, internet websites, and TV shows is dead wrong about everything it thinks it knows about all of these issues. And I think only using multiple experts can we remediate that. A second expert could explain the roots of this disordered thought, on the part of fact finders, and how it distorts our ability to rationally consider information. My colleague, Heather Kuklo, and I have written about how this is even worse in cases involving questions of race, of gender, and of ethnicity. Science moves faster than the law. We know that. The legal system has to have an opportunity to catch up rather than to allow junk science to be the major influence. What I am suggesting, I believe, would do that. Okay. I don't think we can, I'm just about done. I don't think we can understand anything about how the legal system deals with criminal defendants with TBI without a fully textured consideration of questions of access to qualified experts. I think TJ is the redemptive strategy. But I also think all participants, lawyers, judges, expert witnesses must get the significance of TBI, not just in death penalty cases, but going back to the simplest search and seizure or confession case, even if the charge is a very, very low level one, to understand that, to really understand how this could work in the system. Only then would justice be truly available for these people. So where is my title from? Again, Phil Davis got it right. Bob Dylan's song, When the Deal Goes Down. My bewildering brain toils in vain through the darkness on the pathways of life. Each invisible prayer is like a cloud in the air. Tomorrow keeps turning around. We live and we die. We know not why. Will we change when the deal goes down? In a great book, Professor Richard Thomas, a Harvard professor who writes about Dylan, says this song reflects a deep sense of humanity and of survival. I think he's right. And when a lawyer represents a defendant with TBI, he or she must exhibit the same deep sense of humanity to enhance the client's chance for survival. I think it can be best done through TJ. And a PS, Heather Cupelo and I have created a 10-week webinar course in this exact issue. If this is something that really you want to know more about, we have the link up here and you are welcome to join us. And I have at the end of these a couple of pages of citations. And I, Julie, am done leaving. Wow, 18 minutes for questions. I see we have 21 questions, so let's go at it.
Let's get going. Thank you
I may
so
take
much.
another sip of water first, by the way.
Please, please. Thank you for that. That was fantastic. And we do have a number of questions. The first being regarding treatment modalities, is there much available today psychotherapeutically and pharmacologically for those afflicted with TBI?
When I have, it's a great question. And when I read about it, it always says, we're on the precipice of finding something, you know? We are about to make that great new discovery. To my best of my knowledge, it hasn't happened yet. May I, by the way, stop sharing and go back and get the whole screen up again, Julie? Is that okay?
Please do.
Because
yeah.
I'm not saying anything else from this, okay?
Yep, that's fine.
There we go. Okay, good.
Great.
I can see you.
The next question is, are there any common errors that psychologists commit related to evaluation, presentation, or cross-examination for TBI?
What a brilliant question. I think the answer is sure, maybe sometimes, but it all depends on the expert witness's connection with the lawyer. I have talked to so many, and I do much more, you know, I teach psychologists and psychiatrists actually much more than I teach lawyers. And I've had so many say to me over the years, you know, the lawyer calls me up, he hires me, and then I don't see him again until we go to court. And I think that's malpractice, Julie. I think my mentor was Dr. Bob Sadoff, may he rest in peace, the best forensic witness I've ever known in my life. And I would work with, Bob would come from Philadelphia to Trenton, which is not really around the corner, half a dozen times to meet with me on a big case. We would go through his testimony patiently, and that taught me what I should expect from expert witnesses and what I demanded. I don't like to use the word demand, but what I expected. And if a witness didn't do that, it was, you know, one and done. I think that's really the question. I think it's up to the psychologist to say to the lawyer, look, this is very, very complicated stuff. The judge doesn't know anything about it. The jury doesn't know anything about it. Let you and me go through this. Because once the expert witness gets on the stand, he or she is a teacher. To teaching the jury. And if the lawyer and the expert are not on the same page, it's going to fall flat. I mean, I could do a whole rap on bad experts I've seen. You know, I'm not going to do it, but it's all that kind of behavior. Does that answer the question? Okay.
Yes, thank you. Next question is, the long-term effects of a single mild TBI are clearly not the same as the results of a major TBI with loss of consciousness and brain imaging that documents tissue damage. Is there a risk that legal contentions about the effects of a TBI may not reflect the severity of the TBI?
I mean, I have to look at that from two different issues. I believe the expert witness has to explain all this and has to say, look, there may be some TBI that's not long lasting. This is not one of those cases. I mean, we say that all the time. Well, the guy went to a therapist a couple of times. That doesn't mean he's crazy. Something, of that sort. Or, well, in an accident case, she had to stay away from yoga for a week. What does that mean? I think it's up to the expert witness. And again, the lawyer working together. This is going to be my C major chord for this, Julie. Now, the lawyer and the expert need to sort of figure this out. The cases that I have, and I've given many, too many sites, I know. But again, they're all on the slides. Anybody can read them if they want. Virtually every one of these are, oh my God, hit your head against your desk cases. These are not, well, maybe, he got dinged once. I am hopeful, by the way, apropos of that. It's going to be very interesting, I think, that all the stuff that has come out about football players, the guy who was the end for the Patriots who allegedly killed someone and committed suicide in jail, that I think is going to add to this. Because it's always, he got his bell rung, put him back into the next down kind of thing. And we're now realizing, no, that doesn't work. It's the same thing with hockey. We now see how the year of death of people who do that is so different than, than you and I. I mean, it's interesting. A friend of mine sent me just whimsically a John Oliver tape yesterday about professional wrestling. And I am not a professional wrestling fan. And how the levels of TBI that people suffered there and kind of what happened afterwards. So clearly that's going to be different. But when you see it in sports, because that's, quote, different, because they will look like, in the words of that opinion, altar boys. They're good, productive members of society. That's going to be treated very, very different.
Next question is, was an insanity defense ever raised for Lisa Montgomery?
No. It was discussed, but it was not raised to the best of my knowledge.
Next individual says that your talk today prompted them to recall their reading of Joel Norris, and they'd like to know if you believe most serial killers have experienced some degree of TBI.
I don't know. I mean, I sort of stay away from serial killers on purpose. And I always get a question when I talk about the insanity, what about serial killers? And the answer is no serial killer has ever been found NGRI, except possibly a nurse in Pennsylvania in the 1870s. That's unclear, but none of the cases that anyone in this room has ever heard of. It is certainly possible. It's certainly likely. But I also don't believe it was often ever raised in court. I think some of the people who are serial killers, their level of narcissism is so profound, they might have prevented their lawyers from ever talking about it. It's a great question. I have no idea.
Next person says, thank you for thought-provoking talk as usual. They have a question about the Montgomery case. She did have a neuroscientist testify based on PET scans, et cetera, that she suffered from hysterical pregnancy as part of an insanity defense. This was considered junk science by the opposing experts. Is it possible that such testimony backfired as it obscured the genuine impairments that should have impacted the death penalty decision?
That's a great question. I was wrong when I said no. In fact, she did have a failed insanity defense, but it was such a terribly proffered insanity defense. I think unconsciously I kind of made believe it didn't happen. That one is on me. That's a great question. And again, I've written this article with my two colleagues, Heather and Allison Lynch. We wrote an article from which this presentation is taken and will be coming out in the next couple of months, I hope, in the Rutgers University Law Review. And so I really kind of immersed myself, obviously, in the Montgomery case and all the opinions then. And I winced when I read all of that about the hysterical pregnancy. The lawyer was so terrible. I mean, the lawyer could have said, well, she had Campbell's beans for dinner 7 nights in a row, and it's well known that Campbell's beans make you insane. I am making that up, by the way. It was pretty close to that. So all I was looking at, Julie, at that point was what a dreadful job the lawyer did. And the expert witness was not very good either. I mean, right, the expert was not a good expert. The expert at the end, who I think was George Woods, is a superb expert. But we know, and everybody in this room knows, there are wonderful experts, but you have to be able to find them. But this lawyer was clearly not doing that. And I always believe, I mean, Stephen Bright wrote, and I've followed this in some of my cases, death penalty is not given for the worst crime or killing the cutest victim, which is what we mostly think, but for having the worst lawyer. And in many of the death belt case states, we know that judges purposely appointed bad lawyers. I mean, this is a horrendous thing for me to say, but there's no question about it, so that the death penalty would come in. Play with that in your minds for a while.
So with that in mind, how would an attorney go about finding the right or a good expert?
Email me. I mean, I would think, actually, there's actually an interesting question. In some jurisdictions, and I know more, I don't know, Julie, you tell me, for your programs, do you typically get more psychologists, psychiatrists? Is it split down the middle or what?
For this particular program, I would say the majority are psychologists, but we have been really kind of targeting psychiatry programs. And so there are psychiatrists that are on. Yep.
I mean, what's interesting is that, and there's actually been a few cases about this, that psychiatry, I mean, certainly when I started practicing law, psychiatrists were seen as the real experts and psychologists kind of, second level. Now in many jurisdictions that has changed, but not in all jurisdictions. You just learned yesterday that in Canada, in some cases, you have to have a psychiatrist as your expert witness. So, I mean, my sense is I would, and when I started practicing law in this area, I used to hang out at conferences. I went to APPLE, the American Academy of Psychiatry and Law, every year. I used to write for them all the time. I used to go to their cocktail parties. I used to go to the American Psychology Law Society every year. I always used to, when Joel Dvoskin and Matt Zajac had their sing-along, I have a terrible voice, but I know all the words, right? I used to always be part of that, both socially and professionally. APLS is not as much interest to me anymore since their articles basically have gone, full tilt boogie quantitative. I don't do numbers, and that's, I do theory and policy, and they don't seem to be interested. But I would, if I were a lawyer, I would I would go to my local psychological association, my local psychiatric association to sort of find out who's there. I would also read the cases in my local reporter, New Jersey Second, New York Supplement Second, whatever, and see what expert witnesses are going to be the ones who seem to win more of the time. And that there's usually a reason for that. It's hard work for the lawyers, but it's work they got to do.
Next individual would like to know who pays for the multiple expert witnesses.
In my theory, that's a great question. That's a step away. I think what I want to see is I want one good public defender, death penalty specialty office take this argument and make it. And I will tell you, I filed an amicus brief in the U.S. Supreme Court in Ake versus Oklahoma. And some of Justice Marshall's opinion comes right from our brief. So I have a vested interest in all of this, but I am hoping that somebody takes my arguments and makes it into a legal argument and then says to the judge, the state has to pay for this. The state pays for one, the state has to pay for two. If this was a case in which there was you needed both a psychiatrist and a psychologist, someone with severe mental illness and a cognitive impairment, they would have to pay for both. So there's precedent in that, different kind of precedent to be sure. That's what I would do.
Next person says, how can the examining psychologist follow principles of TJ while avoiding the advocacy rule?
Avoiding the advocacy what?
The advocacy rule.
I think this is a very hard, a very important question, and one that is worth a completely different topic, a different presentation. I don't think there's, I'm sorry, Julie?
That means you want to come back and give another talk for us?
Sure, right, exactly. We'll talk about that next year. I think, and it's very, very important. It's something I think we need to think about. I don't believe in neutrality. I think Bernard Diamond was right in the 1950s when he said, the idea of a neutral expert is a myth. I think people sign up for a side. Randy Otto, I don't know, I know Randy is one of your other speakers. I don't know if he's here or not, has written about this wonderfully, and other people have as well. I think once a psychologist or a psychiatrist says, yes, I'm going to be on the stand, I'm an educator. That's what Bob Sadoff always said. I'm here to educate, but I'm clearly taking this point of view, because if he didn't take this point of view, why would I want to call him as my expert witness. I think it can be done. Many of us in TJ world are psychologists. One of us on the board of trustees or directors, whatever we call it, Astrid Bjergden is a very well-known forensic psychologist from Australia and a good friend of mine, and she has written about this in her work, but others have as well. So if the person who asked this question is interested, if you want to pose that to the Therapeutic Jurisprudence listserv, it would be a great question because there are so many wonderful psychologists on that who are TJ adherents, and send me an email and I can set you up.
All right, let's see here.
We still seem to have 23 in chat and 4 in Q&A. I don't know whether that still includes all the ones you've seen.
Chat are internal.
Oh, okay, good.
There were some issues with people trying to sign on, so we were trying to figure out what was going on.
Has there ever been a Zoom meeting in history, Julia, that did not have issues with people trying to sign on?
Exactly. This individual says there's research available between TBI and intimate partner violence. What's your perspective on this and documenting this relationship?
I think it's very important. I think there is a lot of, it is not, in the cases that I read, it was not a significant issue, but I think certainly as time goes on, as we're learning more and more about the whole impact of trauma and PTSD and intimate partner violence, I think this is clearly going to kind of, make its way into the tent. I didn't talk about it here because it was not relevant to any of the cases that I read about, but I think it's huge. And if I were somebody who was doing intimate partner work, this would be number one with a bullet. This would be one of the things that I would look at immediately and in all cases. Great question.
And next person says they agree that TBI should qualify for NGRI.
Right.
They're giving their statute definition in Michigan, but let's just talk in generalities. How would TBI fit into, would it qualify under intellectual disability or mental illness? Or how would
it's interesting. There's also, and this is an embarrassing thing to say, many states have, and Carl Menninger, not the famous psychiatrist, but the lawyer Carl Menninger, who's my generation, writes about what's called the idiocy defense. Isn't that terrible, Julie, to call something the idiocy defense? And that applies to people with intellectual disabilities who plead insanity. And I had one case like that in my life. One of the most interesting cases actually I've ever done that has nothing to do with any of this. I think that a person is TBI a major mental illness? I mean, one of the questions is, one can say and one can argue that in the definition of mental illness, if somebody's brain is so injured and so damaged, that's a different kind of mental illness. It's clearly not like schizophrenia. It's clearly not like bipolar disorder or any of those other things. But I think it qualifies, and it might also qualify, as you said, under a certain kind of intellectual disability. I would have no problem arguing that at all if I weren't retired.
All right. It looks like we have gone through all of the questions.
And what time is it? 2:59.
I know. Look at that.
That's brilliant. That is
yes,
great.
It is. Thank you again for all of your time. We really, really appreciate it. This was fantastic.
Well, thank you. I enjoyed it. I hope your participants enjoyed it. I'm looking at the numbers. Virtually everybody has stayed, which is just amazing. And I seriously, kidding aside, next year, if you want to email me again, you know where to find me.
I absolutely will. Thank you so much.
Thank you, Julie. Thank you, Anthony, very much.
Enjoy your afternoon.
Take care. Have a great rest of the day. Bye.
Bye-bye.
Afternoon, Michael. Okay, folks, I'm going to stay on for an additional maybe 2 minutes. I'll set a timer on my phone. Please use that time to grab the CE link. Otherwise, have a wonderful rest of your day. Thank you, folks.